an IPR policy. This is an overview. As you can see, this webinar will be recorded. It will be posted to the website, so it will be accessible to those of you who are on the call, as well as anyone who wasn't able to schedule it for today. At the same time that we are conducting the webinar, you'll notice that we have a chat room open in SoapHub, and that website, the link is on your screen. You should be able to see that. And that's where the bulk of the chat during the presentation will go on, as well as you have the ability to raise your hand there if you have questions. You will be able to ask questions during the webinar, but we won't really be able to know that unless you raise your hand and ask to speak. However, we may have some folks who are on audio only, and since you won't be able to raise your hand, you'll have to, at an appropriate time, I guess, let us know that you have a question to ask. As you can see, also on your screen are the directions about how to use your telephone if you prefer not to use the speakers on your computer. So what I'd like to do now is really turn this over to the folks that can give you the best information, talk about the membership agreement, talk about the IPR policy, and really answer questions. So our first speaker this afternoon is Jamie Bryce Clark. Jamie is from OASIS. He is General Counsel at OASIS, advising them on legal and policy matters, as well as the consortium's extensive liaison efforts that they do. He is a real expert in e-commerce and information technology. I'm not going to read you his long resume, but he is very knowledgeable, and we've been very pleased that he has been able to really shepherd a lot of this work for us. So, Jamie, assuming that we now have audio with you, I'd like to turn it over to you to go ahead and begin the meat of our presentation.
Well, first of all, let's see if you're hearing me.
Yes, we can.
Super. Okay. For the sake of our folks who were running the session, I wasn't getting where we wanted to with the landline call-in, so I simply plugged in a mic and I'm doing this over the webinar VoIP session. And good afternoon to everybody. Here's where we are. There is a vote out to the membership of the IDESG right now to approve a proposed membership agreement and proposed IPR policy. The vote was launched on the 3rd, and there's information that will be projected at the end here in the webinar about just exactly where to find that ballot and how to respond to it when you're done. But I'm here along with David Rudin from Microsoft today to talk about what these agreements do and how it was that we ended up proposing them from the Governance Special Committee, formerly the Governance Task Force, for the plenary's adoption. Bob Blakely and the rest of the officers talked about this at our last plenary meeting. The group assented to the ballot that's open, and we will now we're now in the period for voting on adopting these agreements. Here's the short version. Today I'm going to tell you a little bit about where they came from. Then we're going to walk through the membership agreement briefly. Then we're going to walk through the IPR agreement briefly. Then we're going to take questions. We might stop a couple times for questions along the way. But first, let me tell you what we're really up to here. All right. When the IDESG was started, we did have a draft membership agreement, and we did have an IPR policy in hand, which it was thought might be the basis for the organization to do its business. But at our initial kickoff plenary back in, I think it was August, some of that looked like it wanted some time and work and some consultation. So a number of rules, as you know, but including the question of how we handle the IPR policy and how we sign up members, got kicked out to the governance task force for some work. We spent a lot of time on that over the last 3 or 4 months, and several of our members did excellent work to come up with and analyze and discuss various options and policy issues. And as a result of that, we now have the rules of association we have, and we have these 2 proposals to basically finish up the package of organizational documents. In the case of the IPR policy, the idea is that when we are doing work within the IDESG, whether it's within its committees or the plenary or some other group, we want to make sure that the stuff that people tell us to do can be rolled up and put into other outputs of the IDSG, whether it's policies or standards or advice or best practices or websites. We want to make sure we can roll that up and use it and have it freely available to everybody without the kinds of problems that would be associated with copyright claims or licenses or folks objecting to our use. We want people to walk in the door of the IDSG and realize that when they're here, they're letting us use the stuff they're telling us so that we can then reuse it and have the opportunity to turn it into useful material for the world, for stakeholders. The idea of the membership agreement is that we want to make sure that when somebody does that, they and the organization they represent, if they're from an organization, whether it's an employer or an association, understand that they've made that promise so that if we ever have doubts later about whether something has been freely handed over to us for reuse, we can prove it up. There are a couple other little things going on in the membership agreement, which we'll get to in a few minutes, about designating which class of member you are and doing other things that make it easy for the Secretariat to administer the membership and make it easy for the members to be properly classified under our rules of association. But the big picture here is that the membership agreement is a contract, and it says we're going to obey the IPR policy. And the IPR policy says if we give you our stuff, you can use it. And I think everything else we say today will probably be an elaboration on that simple theme. And if that's all you take away from this, that's enough. That's the plan. It's very much like a number of other organizations, whether they're trust frameworks, standards associations, de jure bodies, trade associations. A lot of other groups in our field do things approximately that same way with some variations. And so we're just trying to make sure that the IDESG has the benefit of that approach as well. Now, having said that, looking at our outline for talking about this, okay, maybe we'll hold the discussion of when the ballot occurs and how to vote, what else people should do, and how they should handle it if they have questions till the end, because I think you had a slide for that. And I'll just dive right into the membership agreement. First, we're going to talk about the membership agreement. Then I'm going to introduce my colleague David Rudin from Microsoft, who also was heavily involved in the drafting here. I'm going to ask him to talk us through the IPR policy, and then we'll look for questions. And as a reminder, there's a SOAP web conference facility that was at a URI that is projected here and also was available in the announcements. And we will not necessarily be responding in real time, but we will be watching there for questions as we go forward. So, membership agreement. I'll leave it to the folks who are running the slideshow there to see if they want to flip over to the membership agreement itself, and they're welcome to do so. But we're not really going to do a legal review today. We're just going to talk about what's in this thing and what the main features are and why we did what the Governance Task Force and then Governance Steering Committee recommended that the organization do to it. This will look familiar because if you were with us earlier in the game, back in August when the Secretariat started signing people up, this is a modification of the form we had in the first place, which is collected by the Secretariat whenever we get a new member. Basically, the idea, there you go, good. The session, the web session on my end looks like it's showing the right stuff now. Thank you. Basically, the idea is that this is a short contract that every member enters into. And you can see that in the first paragraph, it simply says, you can give us your member-specific information in a Schedule A, which we'll see when we page through this, that tells us who your contact is, which persons are entitled to participate in the organization on behalf of your organization, if you are one, where you want us to send notices to you, and you can change that from time to time. You aren't stuck with it forever just because you put it into this contract. We do ask people to give us that information when they sign up. Of course, eventually that becomes part of a database that the Secretariat manages, and they already have that data on current members. But everyone, I believe, and we may ask the Secretariat to talk a little bit at the end of this session, I think everybody will be asked to re-sign this in the new form, on the same form, when this is rolled out, assuming that it's approved. Now, all that Section 1 there does at the bottom of that first page is say, give us your contact data and your list of names so that we can use them. The business end of this thing starts with Section 2 on the next page, and it says, we will abide by the rules of association, which if you have taken your eyes off us for a little while, it's the stuff we used to call the charter and bylaws. Now it's the rules of association. But basically, we agree to obey them. And we aren't asking people to agree to obey any changes forever without giving them a chance to rethink it, because this is a contract. And if you take it home and ask your headquarters or your legal department or your suits to sign this, they're going to ask, well, what am I signing up for? What other documents are part of this, and what do I do if things change? The answer is the contract asks you to agree that you're willing to comply with the rules as they're published when you sign it. The contract also says that the IDSG can change the rules, but if they do, they have to put them out with at least 30 days notice so that you can see the change coming, and you have the right to withdraw, thereby avoiding the effect of a new rule that isn't agreeable to you before that time is over. So we're basically putting ourselves under the constraint that if we change any of these rules that are incorporated into a reference in this contract, we'll let you know in advance. You'll get a notice in a specific way, and that way, if you don't like it, even you probably have seen it coming for a long time, because of course the plenary and other official bodies act on these rules. But if the first time you hear about it is when you get the notice that it changed, you've still got a month to analyze it and decide you want to stay, or walk away if somebody in your company or organization thinks that the rule change is unacceptable. Frankly, this is a device used by a number of other organizations. It seems to work well. We don't anticipate that there'll be a lot of changes to the document, so it's not like there's going to be a lot of activity here, but there is a mechanism for change that gives signatories to the agreement a chance to respond. The next section, which is already still on the screen, basically takes the same approach to the IPR policy. And we'll be talking more about the IPR policy in a little while, so I'm not going to harp on it right now, but the same idea applies. You sign this, and you and your organization are agreeing to abide by the IPR policy now. And then, if it changes, you'll get notice, and you're going to continue to be bound by it only if you decide to stick around after the changes take effect. There is also an antitrust clause here on that page, which I don't think I need to mention other than to say, yes, we do want people to obey the antitrust and competition laws. There is also a clause 3 at the bottom of the page now showing that essentially is comfort to lawyers wondering just how much licensing is being given out here, and says there's nothing implied here. The only licenses you're giving are the explicit promises, which live, of course, in the IPR policy. If you flip over to the next page, top of page 4, the contract applies until it's withdrawn or you leave. You have a way to, in Section 5, designate where notices are sent. The organization commits to where it's going to send notices so that you know which website you're supposed to watch. You're only tagged as having received a notice if we send it to you by courier, or if we send it to you by physical snail mail, or if we send it to you by email and you've acknowledged it so we know you got it. So that may sound trivial, but one of the things people run into sometimes with home office approvals of contracts like this is they want to know that the thing doesn't get modified just by somebody sending them an email, which they might never even notice. This is how we address that issue. There are a couple of other provisions in here which I don't think are that interesting. You can't assign the agreement. Everybody signs their own. Going over into the next page, Section 7, there is the standard boilerplate indicating that this is an enforceable agreement and how it is to be enforced. And then we get to what I think is actually the important stuff, which is the signature and Section 8 immediately above the signature. Thanks, Kay. That's right there. And what it says is, will comply with the requirements of the ROA, and the person who is signing this on behalf of the organizational member is authorized to do so. As a practical matter, what that means is if you are the designated primary representative, the voting person for your entity, and you're an organizational member of the IDESG, you may or may not be the person signing this. If you are also happen to be someone who's authorized to sign for your organization or corporation, feel free. But if you're not, we want somebody who's actually legally able to sign contracts for the company in question, agency, entity, association, to be the person signing the contract. And we'll see as we get into the IPR policy why that's important. Let's flip over to the next page, which is essentially the informational supplement. And without going into a lot of detail here, this is the data that we gather anyway that the Secretariat uses to determine what kind of member you elect to be, what category you claim to be in, what name and what contact name you use, where you want to be contacted, and who your alternate member representatives are. In other words, folks who can act for the member representative. And then you get down to the bottom in G, and you're designating your member associates. And that is everybody who is entitled to participate in the IDESG on behalf of a organizational member. It's important because essentially if I am one of 4 people, for example, who signed up for the IDSG as a member on behalf of my company, Oasis, then while I might be the representative, I might be the one that votes, gets the email notices and whatnot, fact is all 4 of us are in committees, opening our mouths, saying things, making contributions, and generally speaking, providing intellectual property to the organization and its works. The point of this document is that by signing it, Oasis will be agreeing that when any of us who is there with their authorization participates, we are committed to make sure that they and we provide the license rights in the IPR policy and comply with the other issues described in the membership agreement. So it's one contract for multiple people associated with one organization. Of course, if you're an individual member, it's just one for one for one. It's a little less complicated. If you turn over to the next page, you can see that right there, we then append the IPR policy. So when this is sent out for signature, if it's approved, the IPR policy, as it's then in force, will, after being approved by this ballot, will be right there for people to take a look at. But it is actually also a separate instrument. It will itself be a policy of the IDESG. And so we're going to treat that for purposes of this conversation as a separate document. Now, having talked for a few minutes, probably more than enough, let's stop and see if we've attracted any questions so far, and see if anybody wants to raise issues with what's been said so far about the membership agreement. I suspect it's the IPR policy that's the more interesting one, but let's welcome anybody who wants to ask questions about the membership agreement at this time. And I'm just looking into the chat room to see if anybody's typed anything, and I don't see any questions raised so far. Okay, folks, are you seeing anything I don't, either in the chat room or in the web conference facility? I don't think we have any questions.
Hi, Jamie. It's Laura, and I actually do have a couple questions from Warren. Can you hear me okay?
Yes.
Okay. Warren Blosjo, I hope I'm saying that right. He asks, this is not to be construed as the Federation Agreement, right? First question.
Well, noting that I've heard a lot of stuff about these mythical Federation agreements too, and I'm hoping I'll find out what they are someday as well. I think I know what those are, and no, this isn't that. This is just the ground rules for us all working together in the IDSG to create stuff which might, God willing, someday include Federation agreements.
Okay. And second question is, he also asks 30 days to decide to accept or walk away, or to comment and recommend changes.
The former. And here's the way it works. We're asking the plenary to approve this membership agreement in the IPR policy. The plenary has approved the rules of association. Therefore, if there's going to be a change, long before you ever get notice of anything, we're going to have a debate in the plenary about it. There's going to be proposals, there'll be notice periods, there's a process under the rules of association. So anybody who's keeping their eye on the ball should see anything like that coming from a mile away. Once it is approved and done and cooked, since we want everybody to be on the same page, we will then tell them and give them 30 days to get out. If they haven't been paying attention, just noticed it for the first time and don't like it. That's not something we really would expect would happen too much, because obviously the plenary isn't going to is going to draft its rules, maintain its organization in a way that is attractive for people to stick around, which includes not changing lots of things. But there just has to be that out in case somebody wonders if they're stuck with changes. You have to be able to tell your advisor, no, this contract doesn't bind you to future changes. If a future change comes along, you can leave first. And with that, I think I've answered the question that was raised. And with that, unless we see any other questions pop up or Laura tells me we have something else in queue, let me tell you about a friend of mine who works as an IP lawyer for Microsoft in a much rainier climate than I am. David Rudin got drafted by some of his buddies late in the game to help us craft an IPR policy based on other precedents really quickly and really well, and did such a good job that when we first presented the draft with only a very few changes to our governance task force, everybody liked it. So he's a great guy and has done a lot for us to give us a policy set that we think we can use. And I'm going to ask him, as the principal pen on that policy, to take over at this point in the presentation if we have confirmed his audio, and ask him to walk us through the IPR policy. That'll, Laura, as soon as we get David hooked up on the audio, we can switch over to project the other policy as well. And I'll stay on in case there's questions or color commentary.
Great.
David, are you with us?
I am. Can you hear me?
Excellent. Yes.
Great.
Good.
Well, thank you so much for the introduction and the opportunity to help out on this. As Jamie mentioned, one of the goals behind this IPR policy is to ensure that participants and implementers can get the rights, the IP rights to the contributions and the work in a way that's in line with industry practices. So from a copyright and patent perspective, we want to make sure that people can actually use what's produced. One of our other goals here was to speak frankly, not recreate the wheel. Our goal was to stay well within industry norms and accepted best practices, as well as to ensure that the specifications developed by this group, if any, will be compatible with the larger international standard organization, where there's a chance that some of these specifications may end up. So to start walking through the agreement, the first section is really just a high-level overview of how the policy will apply, and in particular for copyright, how it will apply both to members and non-members. So the idea would be that members would be required to sign, and non-members, by participating, would be subject to the provisions of the agreement as well. Section 2 starts off the discussion around patents. And one of the design factors we took into account here was that while there are some groups that will be making technical specifications or documents that might have patent implications, those are probably going to be the minority number of groups. So we want to both ease participation, but make sure that where we need patent coverage, we would have it. So you'll note that the patent policy only applies to those groups that are chartered to be creating technical deliverables, where other groups that are not involved in those activities won't be subject to the patent policy. The idea being that if you're just writing white papers or position pieces, we want to make the burden of having a patent commitment would be too high and probably prevent progress, while those areas that need a patent policy will be able to take advantage of the patent policy that's attached in Exhibit 1. And then so we'll talk about the details of the patent policy as we get down to the actual policy itself. Copyrights, on the other hand, will apply to all contributions and to both organization and individual members. And the idea here is that by making a contribution, which is basically any materials that you submit for inclusion in the documents, you would be granting a very broad copyright license to the organization, to IDESG, and IDESG would then be in position to republish or modify those contributions. Contributions, you'll note in the next section, are subject to the transparency requirements, so things that you contribute will be publicly available, except for the few exceptions noted where distribution will be limited. Also, you'll note that by making a contribution, it doesn't mean that your contribution will be used. This will be subject to the procedures of the working group, but you are making rights available for that. The next section, the reps, warranties, and disclaimers, is fairly standard. But what is important is that all members are basically saying that they have the right to make the contributions and sign up to these obligations. So if you're making a copyright grant through a contribution, you're assuring the community that in fact you do have the rights to make that contribution. The material is, isn't someone else's that you didn't have the rights to contribute. Let's see. On to chapter. I'm sorry. Next section was section 6. This operates in law by default generally, but it is just a clarification that everyone who's implementing the specifications will be able to take advantage of this, just as if they had signed the agreement themselves, even though there's not necessarily a direct relationship between the person who contributes the material and the person who ends up implementing it. This is just to make clear that that third party can take advantage of the rights under this agreement. For section 7, this is basically saying, while you're a member, you are subject to this agreement. After you leave the organization, your obligations that you took on remain in effect. But as of the date you left the organization, you won't be taking on any new obligation. I think we probably covered enough for the definitions, unless there are any questions up to this point. If not, I'll walk into the actual IPR policy itself, which is in Exhibit 1.
Hi, Dave.
For those of you who participate in standards, you might find. Sorry? Oh, please.
We actually do have a question. I see that Daza has his hand up, so I'm going to unmute him and see if we can hear him ask his question.
Great.
I apologize. I did not intend to have my hand up.
Oh, sorry.
Okay.
Well, you can go on then, David.
Great, thank you. So moving on to Exhibit 1, the patent policy, going back to what I said earlier, our goal was to not recreate the wheel and have a widely accepted policy. So for that reason, we basically took the ISO IEC Common Patent Policy, which is the patent policy that actually an ITUT. So all the major international standard organizations use this policy. And so rather than create our own, we basically took their policy and incorporated their background materials that support the policy. We incorporated those by reference, which you'll see in that first paragraph. So we've taken their implementation guidelines, their software copyright guidelines, and trademark guidelines, and basically incorporated those by reference. And we specifically called out the versions of the policies available as of the date, the current date. So just like Jamie described in the member agreement, this is not a rolling policy. This is a policy that's locked in time. And if ITUT were to update those policies, we would not be subject to those new policies unless we specifically read the agreements to adopt those. We've also made clear that since we're basically incorporating those by reference, we're not copying the policies over and changing the words, but we are reading those policies to basically use IDESG terminology in place of ISO-IC or ITUT language. In accordance with that policy, this is based on the participation of the members for patent disclosures. It's personal knowledge, and there's no obligation to do a patent search, which is a fairly standard process here. If you then scroll down more, you'll actually see the form that is to be filled out. And the idea is that as the specs are developing, participants have an obligation to make patent disclosures within a reasonable time. And when they make those disclosures, they would use this form, and they would choose one of the three main options, and there are some sub-options as well. But the three main options are primarily they'll make their necessary patent claims available under reasonable and non-discriminatory terms with the option of charging a royalty. They have the ability to make their necessary patents available under reasonable and non-discriminatory terms and will not charge a royalty, or they will not make their patents available at all for licensing. And this is in accordance with the ISO/IEC process, and the idea is to provide participants early notice of potential patents and give them the ability to evaluate those patents and potentially have discussions and make decisions accordingly based on those. And I think with that, that probably takes us to the end. I know we've covered a lot, but are there any particular questions?
David, before you do,
Sure.
let me play Howard Cosell, and boy, does that reference date me, and make a couple of points of color commentary.
Please.
On the IPR agreement, obviously you do something like this, you need to send it to your advisor or lawyer and say, hey, I'm getting into this. Is this okay? And it's our hypothesis that they will come back and say, yes, this is pretty safe. It's nothing you haven't already agreed to in other places because they're following a very common industry model. But even at that level, I guess I want to say three things as potential elevator pitch takeaways from this IPR agreement. Thing number one, the patent policy thing is an option. We were told by a number of the group's leaders that there may be groups that want to have a patent policy because they may do independent work. It's a pretty light policy. As these things go, the ISO IEC I2 model is pretty forgiving and doesn't ask for a whole lot. And any entity that's ever participated in any of those organizations or their national equivalents probably has already agreed to this. So it's not a big ask. But even at that, you're only going to go there if one of the committees of the IDSG explicitly adopts the choice that they're going to do patented work and that they want to have their work subject to this extra set of cautions. Otherwise, we're not going to ask, we're not going to worry about patent protection within the IDSG. And since patents seem to crop up in our lives daily these days, you might ask, why would we be willing to go without that protection? And there's a pretty simple answer, and that is that our ecology already has lots of trade associations, standard organizations, and other entities who are creating work under significant and much more protection-laden patent policies. So if we want to do something as an ecology that requires tiptoeing lightly through the daisy field of a whole bunch of patents, and either people don't want to make these assurances in the IDSG in order to do the work here, or feel they need a stronger level of protection or a higher filter requiring more disclosure or more explicit licensing, it's going to be an easy answer. IDSG is going to outsource it. You're going to go to one of your friendly neighborhood standards organizations and say, why don't you guys go do it there and then bring it back here and we'll approve it or disagree with you or tell you we want it turned upside down or painted blue. So just remember, the IDSG doesn't have to do everything, and this policy expects that a lot of the work will end up being outsourced somewhere and then brought back with considerably heightened IPR protection, eligible for comment, feedback, or approval by the IDSG. And I just want you to remember that outsourcing idea, because that's why this is a relatively light policy. And finally, if I could lean on Laura or our other controller to go back a page or two and actually highlight that last section of the IPR policy, which is section 8 for definitions. Just want to remind you about something that when you look at it, that's perfect, right in there. These define the acts to which your copyright promises apply. While it's true that sometimes there may be patent consequences if you're in a committee that has a patent election and it's explicitly listed in the charter and you know about it, you're always going to be dealing with the promises of transparency and copyright licensing that say we can use the stuff if you give it to us, we can reprint it, we can put it into other works. What are you giving away? The answer is that defined term there, contribution. Anything that you offer up electronic, written, oral, blah, 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 take a look, is a contribution. Unless you explicitly say, and this policy gives you the right to say that, this is not a contribution in a conspicuous, express way at the bottom of that definition. So all of our interchanges, basically our emails, the documents we share, all the stuff that goes on in the IDSG is subject to and available in the terms of this general copyright permission to non-exclusively reuse it and do stuff to it, unless you explicitly exclude it. Note also down at the bottom that it applies to stuff that gets put into a final work product, the defined term deliverable. What are we giving people the right to do? We're giving people the right to take your contributions and bake them into deliverables, which is stuff we approve and gets put out into the public. And finally, the last definition, member, real important so you go home and understand what you guys are getting into. Member means the participant and the organizational member that they represent if they're in an organization, and the affiliates, basically, of that organizational member. So if I'm here for Oasis, I'm binding myself, I'm binding Oasis, and anybody else who's here from Oasis is binding Oasis too. And if Oasis had a corporate cousin that was under its control, you know, Oasis Beijing or something like that, they're bound too. That way you know that if I open my mouth, or if one of my employees or affiliates opens their mouth, you know that you can use the stuff that we're contributing because the IPR policy says so. I just wanted to spend a minute on those definitions because those are the takeaways. Is you're giving up contributions. Contributions is anything you give us unless you explicitly say otherwise, and it binds you and it binds the people you work with who are here. Okay, that's all I had, David. If we want to go over to questions now, let's see. I think I see something in the queue, but Laura might have a hint too. Laura, has anybody tossed a air balloon at us yet?
I am not seeing any questions right now, but I can just remind the audience that if you want to ask a question, you can just type it in that white box in GoToWebinar, or you could raise your hand in GoToWebinar. There's a little hand icon on the left-hand side of your screen, or you could type a question in chat and SoapHub if that's easier. So really, however you want to do it, now's the time.
After a minute, we'll see if we get anything, and if we don't, I'm going to suggest that I turn this back over to Kay or one of her colleagues for a minute to talk about the ballot and also sort of what's going to happen with these agreements if it's approved and how they're going to be rolled out. And Laura, that might mean you, depending on Kay's availability. But let's wait a second more and see if we've generated any questions. IPR lawyers like to go home early too, so we will have no problem with cutting off this webinar well in advance of schedule unless there are questions. David, you were just so darn good you stunned him into submission, I think.
I could probably have another explanation, but I'll take it.
Laura, Kay, you think we're ready to do the wrap-up?
Okay. I'm going to be doing the wrap-up, and I do apologize for my scratchy voice. I think I kind of got a little sick this time of the year, but hopefully you can see on your screen now the dates, and we have a 14-day window to cast your ballot. And this is just, as always, this is for eligible voters, so this is not for every single member of the IDSG, but if you are an eligible voter, there's a 14-day window. That window closes at noon on December 17th, so the voting ballot is now open. And in order to vote, you should have received an email if you're an eligible voter with some detailed instructions. But basically, I'll just show you on my screen here. You go to, let's see if that's coming up. Okay, you go to idecosystem.org, you log in. If you haven't created a login, you click one of these to create a login. After you've appropriately logged in, then you click this voting main menu button and you'll see the ballot. Only eligible voters that log in will see that ballot and be able to cast a vote. So if you have a login but you're not an eligible voter, you're just going to see a little message that says, you know, you're not an eligible voter, something like this. But if you are an eligible voter, you have logged in, you should see the ballot on this screen when you click this voting button right here. And if you have any questions, just email us right here, checking it all the time to make sure if any issues come up, we make sure that you're going to be able to cast your ballot one way or the other. And I do want to just highlight that all of these documents that we're discussing right now are right here on the sidebar. You can refer to the Rules of Association, download that document, download the membership agreement, the IPR policy that we just reviewed. Obviously, you want to look at those before you cast your ballot. If I'm missing anything, feel free to chime in or ask a question.
No, Laura, I think that's great. I see we have one question that did pop up in the chat hub eventually. Somebody asks, is there a provision for contributions of IP work with no modifications allowed? And I mean, not just no, but heck no, Robin. And that's because we've learned out here in the woods of standards work over the years that if you give a group a piece of work, they may adopt it, they may use it, they may not use it now, they may use it later, they may want to use it for something other than was intended. Basically, the idea of giving somebody the right to contribute something but only under conditions puts them in too much of a unilateral position. So it's I think pretty much the universal conclusion of standards-like entities that's a bad idea to permit that kind of conditional work. And in fact, if you look at David's draft, which is before you for approval, you'll see there's explicitly a statement in there that says, if you give it to us, we can use it, but we don't have to use it. And we can use it, you know, we can snap it together with different Lego blocks and use it in a different way because we don't want our committees to be constrained by some kind of strings that they might not be able to interpret correctly or understand. We just don't hand stuff off to the ESG unless you're happy to have it reused, would be our concept. And Robin comes right back with an even better question. Does this include code? I'm reading off of the webinar. Yes, in the general case, because the contract and the agreement and the process all talk about any contribution. So anything you send in is subject to the terms that are written in the proposed documents. Usually, if you're going to create code, if you're a you know, a GitHub kind of or Slashdot kind of code facility that is more optimized for sharing and creating common code, usually there will be other provisions involved that are not present in this policy. I'd say that an entity that's optimized for shared code creation and management tends to have some additional IPR terms that make it even easier to pick the stuff up and then have the exact terms of reuse clear. So I'd say it's not optimized for code, but we can't say anything's not included. David, do you want to second guess me on that one?
Well, what I would add is that if the policy in particular incorporates the ITUT's software, copyright software guidelines into the agreement, where it's clear on points that software should generally not be normative. It should be, you know, for reference purposes or informative. But there is, you know, is a document that deals with the rules of software and how it's used. But for the most part, I think the general rule is that the purpose of this policy is optimized for the development of specifications, and it does contemplate the development of accompanying software, but that software is generally more of an implementation of the spec and doesn't supersede the spec.
That's a good point. If you're taking a model or a concept or a specification or a set of business process steps that are in a output of the IDESG, then the code absolutely that you create, you know, is an implementation of that. And so at a minimum, it enjoys the benefit of the licenses that are created by the policy directly. But of course, we only get into that ITU stuff if we're under the patent policy section, right, which is something that a committee would have to opt into. And I'll just say, informally, it's my guess that very few of them will opt into that. I think you'll find that most of the IDSG committees are happy operating without the additional layer of having to go out and get explicit assent to a patent policy from each of their members. Any other questions showing up in the queue? I'm not seeing any. If not, I think we might thank people for their attention. Point out to them the ballot closes on the 17th, that the plenary has put it before you, and that we think, based on the folks who put time and energy into this on a donated basis, that it's a pretty good answer, so we hope it passes. and you'll be hearing from the Secretariat shortly after the close of the ballot. Anything else, folks?
Yeah, thanks to Jamie and David for presenting. We appreciate it, and thanks to everyone for attending.
Thank you.
Thank you, folks. See you soon.